You're listening to the Immigration Lawyers Toolbox podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode number 397. We're getting close to number 400. We're going to have one of my favorite episodes because I actually learn a lot. It's our interview monthly with Gregg talking about federal litigation. Gregg, obviously, Kevin A. Gregg of the Immigration Review podcast, which is, it's very popular. It's very competitive with my podcast. And as you know, we have it in our small community where most people are nice and help each other. We come on each other's podcast. So it's a pretty good situation to help each other out and learn a lot of interesting stuff and have some commentary, all that stuff that you're used to. We've been doing it for years now. So I appreciate you coming in to check that out. As a reminder, we've unleashed the courses, the E2 courses, investor, owner, EB1A, extraordinary ability, how to do them, samples, all that kind of stuff. They're up on our community page, premium courses. But if you're a part of circle.so, go on those, click on those links. They'll give you information about the course. If you're not a lawyer that's already a member of our free community page, which has a lot of training sessions, courses, all this kind of stuff is available. Email me at info@immigrationlawyerstoolbox.com to get started. Hopefully, I'll get the landing page up and running sometime in the next 30 days. So I can just send you there. And I'll have a lot of the data that you need. But that's that. Also, Roman Zelichenko's special special session, seminar. What do we call it? And just like my last program, I don't have the copy open, but he's doing this tennis program 2 or 3 days. You people go to upstate New York and play tennis, do training on business, on marketing, but also have fun. And he's actually I'm going to be recording with him tomorrow. Hopefully he'll be a regular monthly guest on the show. So he'll talk about more detail about what's going on. But I'll leave it as that. If you don't know Roman Zelichenko, you should be following him on LinkedIn right now. That's the best place. He has a lot of good content. He puts on Facebook too, but I try not to go on Facebook too much. So Roman Zelichenko, I'll have the information in the show notes. So you have that. Let me make a note about show notes. And check that out. If you're into tennis, which I am, if I was closer, I would. Flying across country is hard for me, but especially if you're single or your kids are older, fly over there and go. It's going to be a blast. I really recommend it. I'm sure it's going to be a lot of fun. Having said all that, none of the information provided here is intended as individual legal guidance. Please consult with the attorney about your case, but y'all know that already. Let's get the show started. Hi, Kevin. Thank you so much for coming back on the show.
My pleasure. Happy to do it every month. My pleasure. These are wild times in immigration, and I'm honored that have a bit of a platform with your program and mine that I can talk about it. I try to speak for the immigration lawyer community, but I don't know how good I always am, but I try, and it's nice to be able to speak.
I think like people listening a lot of times tell me it's just a relief hearing someone that's like also like just frustrated or thinking about this stuff. Even though we're all scattered across the country, it really brings it's the best use of the internet in my opinion. Bring the community together. There's so many
Yeah,
bad things going on the internet. At least there's some positive out there too.
yeah. It's I try, and it's fun. It's cool to have a voice. I don't know
For
who's
sure.
listening, but it's cool to have a voice.
Yeah, and your podcast, I mean, you immigration review podcast, you sit and read all these cases, which is incredible. I mean, how many hours a week do you spend studying case law? Just
It's
this
a
case law,
lot.
stuff you need for
I'm
work.
backed up 4 already. It's only Tuesday. I did 1 today. I'm gonna do a couple more, at least 1 more after my son goes to sleep, because you can't get backlogged with it or else it's just overwhelming. I gotta be done reading the cases by, like, Friday afternoon, like, or else you gotta kill them as they go.
Is it like Saturday
So
Night Live where you have to have the skits prepped up for Saturday nights because there's no getting
oh,
around that
yeah, like,
deadline?
I try to record Friday night if possible, if not early Saturday morning, and, because then the editors go to work, I finally have some editors, but,
Oh, really?
no.
Congrats! I didn't know that.
Thank you. I still give it the final edit, and my editors are good, but final edit's still needed. But yeah, no, I got to be done with the case reading though. You got to get on top of it, and when
Well,
the
I
circuits,
love behind the scenes. Do you read a case then record, or do you read all
no,
of them record in one sitting?
usually have them all read and outlined, and then I record all in one sitting. Usually, now if I'm going to be traveling that week, or like the last 2 weeks, I was on vacation, but it was like mid thing, so like I recorded some, and then Liz at my firm she did some, and so there I recorded earlier. But usually it's all in one sitting. Time is time. I find it's a better podcast if I do it all at once because then you can link the cases together a little bit. Like the Third Circuit just said this, the BIA just said this, pretty interesting happening in the same week, that kind of stuff. you can't do if you record
Yes, true.
before in midweek.
And before he's one more thing is I get like weekly Justia updates on all the courts, and there was one a week or two ago I had like 17 cases, and as I opened it, I'm like, oh, Kevin screwed this week. And then was that recently?
There has never been a 17 case week. The most cases there ever were, I'll tell you right now, there were 11 cases in August of 2022. I know that because I was moving the exact same week and I almost died. There were 11 cases.
Well, I have it here, July
Um,
25th. So this one is 14 cases.
well, I don't know what you're counting. You're not. That's not just precedential immigrant circuit decisions and BIA. That July 25th, you say?
Yeah, July 25th, 2025. I mean, it probably sucks up anything that just touches upon immigration or he mentions it.
Yeah. The episode 274, the episode that published on July 29th had one, two, three, four, five. That was a 6 case week. No, that was a 7 case week. So that's a big week. But you must be counting district court cases or unpublished decisions as well, or
Probably,
something.
yeah. I get the Justia roundup and I just skim it to see if there's anything like adjustment
Yeah.
status USCIS related. A lot of times cat and stuff I don't do, so I just like I don't really pay attention to it. But yeah, most of it was just stuff I wouldn't do. There's one here about
But
like
yeah,
U visa lacking authority and this and that. But sorry, go ahead.
the BIA is killing me because they're publishing like every week now and multiple a week because they finally found their voice. I wish they would have found their voice during a Democrat attorney general, but they finally found their voice and they're going ham. And so they're killing me. They really are. Although nothing this week. It's been the BIA has published almost every week since March. I don't know. There was one week they published 5 decisions. The BIA.
Dang. And there was one decision. I'll let you know because there's one decision Taylor Levy posted about like they paused expedited removal for port of entry entrance. I think it was like Churla v. the late Bondi or something like that. I'm reading the cans. That's popped up like a couple days ago.
So I don't usually do the immigration decisions that come from district court that are, these big trying to get an injunction against the executive type cases. Those like knowing the ins and outs of how to do federal litigation is just not something that I think you can get from the podcast. I'll
Yeah,
mention them often at the top of an episode, but they get picked up by Law 360, those big things, and I'm not going to go into the ins and outs
yeah.
of that because I don't think it's very helpful to what the community is doing. I should have got that one at the top of an episode. I know about it, but like I'm not usually including those ones unless the Supreme Court does it.
Well, that's why you got to listen to my podcast. For on Mondays, I see these pop things that pop
That's right. That's exactly right. That's 100%. There's enough love to go around.
well, very cool. Let's
But
jump into it.
I,
What's the first case you want to go ahead?
well, having said that, like I wanted to talk just about the Trump et al. V. Casa et al. Decision again. I think we talked about it last month, but just to reiterate that the court could have decided the birthright citizenship issue. It didn't. Instead, it got rid of nationwide injunctions, essentially, for no other reason except to be cruel and
Hmm.
based on 16th and 17th century British precedent, I believe. Read this dissents to really understand what's at stake, and it's nothing short of our democracy. But important, the court very much left open the viability of Administrative Procedure Act cases, APA, which is the main way that immigration lawsuits happen at the district court level. It also happens to be the main way that big corporations sue the EPA and the Department of Labor. So maybe that's why they kept it. But that's what immigration does too. And of course, class actions. So the birthright has transformed into a class action. Our TPS lawsuits, for example, traveling under the APA. That's why we survived in the Eastern District of New York. We just filed another one. We're going to go for class cert in the DC Circuit. So very much still alive and well in immigration, notwithstanding Trump et al. V. Casa et al. And it's just this whole thing is ridiculous. The Supreme Court should have put birthright citizenship to bed. There is no circuit split. Judges are calling it the easiest decision of their career, and yet the Supreme Court delays. And like, what happens to non-LPR cancellation of removal, for example, if you get rid of it? Like, pretty much everyone who applies for non-LPR cancellation of removal, it's almost always two individuals here unlawfully who had children in the United States when they didn't have legal status.
Hmm.
Congress clearly believed that those people were U.S. citizens, else it wouldn't have made them qualifying relatives. I mean, this whole thing's ridiculous. And the fact that we're talking about it intellectually upsets me at how far right the anti immigrant crowd has managed to put the narrative that we're actually, the Supreme Court's permitting this to have intellectual viability that you and I are talking about it right now just pisses me off because this is politics. It's not intellectually honest. And that's, I guess, all I'll say about that.
Yeah, I mean, to use an executive order to upend something that's been like iconic American law, because a lot of countries
Yeah.
don't have what is it, birthright by citizen. There's a Latin word for it, but everyone knows that's the case. So to come by executive order change that, it means like the next person come on change that. You can't go back and forth on birthright citizenship. That's like a crazy thing to just flip on a switch like that.
It's BS. Whatever.
All right, so let's get
It's
into it. Next, next case.
Cantanani, the Attorney General of the United States out of the Third Circuit, is just a barn burner. This case took like an hour to outline. It was just so much going on. Just a giant group of impressive attorneys doing it, and just so much. Mr. Cantanani is. It looks like He's a Palestinian imam who it would appear may have gotten involved, swept up in, to what degree, a bit unclear, in the first intifada in the early 90s. He was definitely detained by Israeli soldiers, as apparently were thousands of other young men in the time. The first intifada, not the second. Don't get me wrong, no intifada is great, but like the second's the one where they were blowing up buses and stuff. The first one was not all peaceful, but it was not the second intifada. He comes to America, he's an imam here, and he starts advocating for the Palestinians. He's been trying to become an LPR for a long time, back and forth in immigration court to the board, keeps happening, saying that he misrepresented in his adjustment application about his affiliation with Hamas and whether he's ever been arrested or convicted in Israel. Back and forth. The immigration judge is steadfast that the guy has nothing to do with Hamas. But the BIA keeps overturning the IJ. Get to the merits of all that in a bit. There was one remand, goes back to the IJ. IJ grants again. They even have an FBI agent and an HSI agent testify in immigration court. And the IJ believes Mr. Cantanani and not the FBI agent. No small thing.
Is the
Really,
IJ
just
still working, or are they out?
yeah, right. No, look, hey, people are credible or they're not. That
Yeah.
incredible doesn't necessarily mean lying, by the way. People forget that. But in any event, big decision from the IJ saying the guy's not Hamas. Any misrepresentation was not material. I grant the green card again. And DHS didn't appeal. 3 months later, DHS asked the BIA to accept its late filed appeal, blaming COVID, I believe. And the BIA can self certify a late filed appeal. The BIA sat on it and then certified it 11 months later.
Wow.
Well, 11 months post IJ decision. You have 30 days to appeal. And so the issue is that permissible? Because while the BIA can self-certify, Mr. Cantanani's position was, look, I became an LPR 30 days after the IJ's decision. Like, there is a statutory mechanism to take away my LPR status, rescission proceedings. Once the IJ's decision became final, 30 days thereafter, I became an LPR under the law. Self-certification be damned. And the Third Circuit said, absolutely correct. Absolutely correct. It's a wild decision. And let me just quote you what they said. One of the things. Oil went into court. They're saying, look, yes, BIA can self-certify a late DHS appeal anytime, even for green card holders. Quote, the implications of this argument are extraordinary. Under this reading of the agency authority, the government has carte blanche to evade the limits Congress imposed on the executive's discretionary authority over adjustment to LPR status and to circumvent the procedures Congress mandated for rescission of such adjustments. That just, end quote, just goes on and on. The agency cannot override Congress. Third Circuit goes all in that this is a separation of powers issue because, again, the statute said once you're an LPR, you can rescind within the 5 years, but
And
can't
why would they
just.
just do rescission? Because the rescission is such a crappy thing for the applicant, anyways.
It is a good point. And by the way, I think rescission proceedings have now. I think it's too late for rescission in this case.
Is it 2 year or
I was
five?
right.
5 years?
The IJ granted it in 2020. Yeah. So I don't even think they can rescind anymore. But in rescission proceedings, ICE has the burden, right?
Yeah.
I don't think ICE thinks that they can meet their burden. The FBI agent and the HSI agent were not deemed credible. And now they definitely can't, by the way. Third Circuit's talking about like the speech that the guy gave is about, when he was pissed that Trump recognized Jerusalem as the capital. There's a pro-Palestinian speech, straight politics, quintessential First Amendment speech. says the Third Circuit. It was concerned that the BIA, quote, penalized Continental for quintessential First Amendment activity, end quote. That is anti-Trump,
But
pro-Palestinian
isn't that
speech.
legal right now? Like for doing that? I mean, Trump administration.
Well, I mean, look, Third Circuit meeting the moment. That's a quote that I
That's
would
a
be
good one.
citing in every single one of these cases that, by the way, seem to be trailing off as the administration loses time after time after time with these pro Palestinian cases. Politics aside, look, it's politics. Recognize it as politics. And everybody should be worried if we're starting to make illegal or anti immigrant
Mhm.
politics. I mean, that's the road to ruin. But the Third Circuit meeting the moment. So yeah, he became an LPR 30 days after the IJ ruled, and the fact that there's a regulation that permits the BIA to self-certify a late filed appeal, that's a bit separate. And how does this apply to other things like a grant of asylum, for example, a grant of cancellation? I think it'll be more difficult, but in both cases, well, both of those cases probably different because rescission is only for LPRs, but still, if this ever happens to your client, this is the first case you should be looking at to see if you have an argument that the BIA cannot self-certify in this circumstance a late filed DHS appeal. It's a huge case.
Yeah.
It's wild.
But
I
this is,
very much
but
enjoyed reading it, even though it took me forever.
yeah, this is an issue that's probably going to pop up a lot in the coming years. So
I guess. I mean, look,
yeah.
the whole they're not being secretive. The Trump administration is saying they look at the INA and they say we are going to use this to the maximum extent possible, and we're going to push the boundaries, probably break them. So this is just one more example. The Third Circuit starts with this quote, where an administrative agency purports by regulation to evade procedures mandated by Congress, it is incumbent upon us to intervene. Give me that legal nerd.
Hey, everybody, I want to jump in really quick between this exciting conversation with Kevin Gregg to remind you that our E2 it's investor owner case. These are when there's a small, less than $100,000 investment, they're doing constant processing or change of status, and they want to run their own business. This is the kind of cases my firm does, and I accumulated some experience in that, and I want to share that with you with samples and breakdowns, what we're looking for, overview of the Foreign Affairs Manual that goes over this section, how to talk with people during a consultation, what to look for, all that, and an EB1A course, Civil Extraordinary Ability, if you want to get into that field. The courses pay for themselves. First course will get you 4x at least what your investment is. So it's a no-brainer to do this. Email me at info@immigrationlawyerstoolbox to join. Lawyers only, and I'm sure you're going to take a lot out of it. It comes with office hours mentorship, so you can talk with me monthly about what's going on. Ask any question, really. Just join the group, and we have a group mentor session. It's going to be very helpful. Let's get back to the show. It
That's what
seems
the
like
podcast.
the third state's hitting hard. There was a case called Sun Valley Orchards LLC versus DOL that Jeff Joseph published. I saw him on LinkedIn. He was talking about it. It has to do with Department of Labor imposing fines on people, and the circuit court saying Department of Labor judges can't do that. It has to be because there's
Using the Supreme Court's decision term or two ago about
Jarsky.
ALJ. Yeah,
And so now, because the people are getting these $1.5 million overstay on voluntary withdrawal or whatever that is, and they're getting these things, like, well, agencies can't sue. So that's going to be
that
a
is a good point.
third
That is a
circuit. So,
good. Jeff Joseph's a smart man.
yes, that was an interesting thing. So that's because these 1% bill for $1.5 million kind of crazy, like unreasonable.
That's a good point. And when people start coming to our firm, that's going to be the first thing I'll look into is what are the Third Circuit. Maybe that's why they put Judge Bove. What's the guy's name? The
Trump's
Trump,
lawyer,
the
personally.
Trump hack who somehow made it to the Third Circuit. I cannot believe. Again, politics aside, when there are three whistleblowers that say he said I'm going to tell the judges to f off when he was in the White House, and when he made a corrupt deal with Eric Adams, and when there's this whole record of him mistreating individuals as an attorney. The Republican senators, they just do not care. They just don't care. It's that he is now on the Third Circuit is a scary thing.
Yeah,
But
they got to
Emil
pack those
Bove,
courts.
Judge Bove, but he is. So now I will read his decisions and report every single anti-immigrant one of them.
Well, thanks for sharing that stuff. What do we have all next?
The final one, De Silva Borges v. Bondi out of the First Circuit. First Circuit doing work. Also very important in this day and age. Look, you might have a client who has no case. That is, if they are a non-citizen. If ICE can, in fact, meet their initial burden to establish alienage. It's always ICE's initial burden. Now, don't get me wrong. if your client's detained, this might not be a game they want to play. And they're trying to detain everybody, but these cases are percolating up when people weren't detained. Fire me. And mind you, if you get it terminated, your client can't be detained anymore. It's always DHS's burden to prove alienage before anything, even for 212 charges.
Well, they pause that. What's the situation right now going on in court where they terminate the case, and as soon as they walk out, they pick him up? Wouldn't that be the scenario that happens?
It's not. You're right. It's not good, but it does presuppose that DHS can establish alienage in that circumstance. But then you're arguing that in expedited removal proceedings with ICE, yeah, in this case, if it's terminated, can they just detain them? They probably can. That termination is not so great now for these people. It's a catch-22. Of course, that also assumes that ICE can establish alienage, but I don't think ICE and expedited removal will care quite as much. And then you'd have to do an emergency petition for review that to the circuit. So yeah, this isn't always great, and you attorneys should be very careful. But that doesn't mean that First Circuit isn't making great law right now, agreeing with the Sixth Circuit that ICE's initial burden under the statute and old Supreme Court case law is not just clear and convincing evidence, but clear, unequivocal, and convincing evidence. And that's based on the language of the statute and Supreme Court precedent, and they mean something different. Quote, unequivocal taken by itself means proof that admits of no doubt, a burden approximating, if not exceeding, the use in criminal cases, end quote. That is a big deal. That is a big deal. And the First Circuit has now issued this decision and the Rosa decision before it, which I also might have talked about on your show, talking about how these EARM summaries, summaries that DHS is filing in immigration court that include an I-213 within them are not necessarily cutting it, especially when you can pinpoint all the inaccuracies in that filing. So the Sixth Circuit is another circuit that has recognized that clear, unequivocal, and convincing evidence is a higher standard than clear and convincing. That's holding the agency to its burden. And here's the First Circuit really just going all in. Be careful how you play this game, how you litigate this issue, but it's a powerful issue for your client, for the right client.
That's the thing, the
And that
right
is
client and situation. Quick note,
De Silva Borges v. Bondi.
I think you might have mentioned earlier, but this Haitian TPS got like injunctioned again or something like that. Are you aware? Are you guys
You
part of that?
can't use injunctioned as a verb.
Okay.
I gotta. Yes, that's our case. They did illegal stuff. They tried to terminate TPS early for Haiti. It was going to expire, I want to say February 3rd, 26. And Kristi Noem was just like, how about August? It's illegal. And we got the most, as what is believed to be the most conservative judge in the Eastern District of New York to agree with us. I mean, this is not I don't like doing this with the judges, but like this is not a historical progressive in the Eastern District of New York. They just violated the law.
Mhm.
And USCIS has rolled over and republished it in their little whiny way on their website. It's very beneath them, in my opinion, the way they issue
Yeah, their
these.
commentary is just
One
snarky
little judge
politician.
in the Eastern District of New York has determined. So even though it's a violation of the statute, we're gonna do it. Like, you lost, guys. I just if you told me that the executive would be acting the way that the Trump executive acts in public during law school, I'd just be astonished. Like, this is not how lawyers and government are supposed to act. Like, you win, you lose, and it's just wild stuff. But always trying to shape the narrative is Donald Trump. In any event, government hasn't appealed their
USCIS.gov
decision.
is like a bunch of tweets at the top where it's just like
What?
it's
It's
just crazy.
wild.
This is a level conversation that's happening.
It's wild. They haven't appealed yet. We're still in the appeal window, but it's possible. It's possible that they don't appeal because very much so. It's going to end on February 3rd. But we just filed a lawsuit in DC to challenge that as well. Because if you read the reasons for not not reauthorizing TPS for Haiti, if you read them, what they had Kristi Noem wrote, right? It reads like an extension. I mean, they're terminating because Haiti is controlled by gangs and it's a violent, unsafe place. The literal reason why you're supposed to extend TPS is because it's unsafe to return those people to that country. The Trump administration knows it because we sued them during the first administration in Sage, and they lost because they tried to fake what was happening in Haiti. And there is not a person on the planet who thinks that Haiti is better now than it was in 2019 or 2018, which, by the way, is astonishing because it was so bad in 2018, 2019. But I mean, since then, what gangs control like 80% of Port-au-Prince and the port, and
Yeah.
the prime minister was assassinated. And it's wild. The Trump administration doesn't care. Their position in court has since been, in our case and in many cases, DHS secretary has inherent authority to do whatever she wants. We disagree. We disagree. And I don't know how much, I'm not sure there's a judge yet who agrees. There's certainly a couple on Supreme Court who do. Hopefully they don't have a majority.
Yeah. Well,
But
that's what
for
they.
now, Haiti TPS extended again through February 3rd, as it
Mhm.
should always be. Like, I don't want to, I don't like trumping up these wins
Mhm.
because, like, they're just breaking the law. Like, we're
Yeah.
just taking it back to status quo.
Well, there's other stuff happening. For example, for the CHNB cases that came in and it was canceled, they're potentially holding on to those adjustment cases, even though they're not supposed. They're supposed to adjudicate them. And same with potentially Ukraine and stuff like that. For U4U
Yeah.
cases are here ended. I don't think they're. I think it was court cases. It's not supposed to like
You talking about the
adjudicate
parole,
those.
the CHNV, the paroles? Like, that's
Yeah.
dead. The parole that they vacated, they stayed the injunction again, but then they, a very comprehensive district court decision, and the Supreme Court just said, nah, meh. I do think that the Haiti, Nicaraguan, Cuban, and was it Honduras?
Yeah.
I,
I think
I
so.
think those. I do think the paroles are dead. I don't
I
think
think they,
that's
they
coming
got
back.
a stop on it. I think those are temporarily reprieve or something like that. That
All
Honduras
right.
one. It just popped up
Well,
a couple days ago.
that's why you got to listen to your podcast on Mondays.
Yeah, I try to keep track of everything. Honduras, that was a federal judge postponed CBI expiration for Nepal, Nicaragua, and Honduras. Protection of 60,000 people. That's a lot of people. So yeah, that happened July 31st, so a couple of days ago. This is August 5th. We're recording this. So there's Northern District of California issued an order that suspends the admin's TPS for 60 while legal proceedings concerning the merits of turning TPS are in progress. So they got kind of a reprieve right there, but this is an ongoing fight, expensive probably fight too, whereas arguing these cases.
Yeah,
As you guys well know, you guys are paying bills on the Asian TPS. You have partnership with that big firm that you're working with. So yeah.
crazy stuff.
Well, thank you so much for coming on the show, Immigration Review Podcast, where you can go to get all these great reviews of these court cases. We just, you cherry picked some of the better ones, so we have it for my audience. Kim, thanks again for coming on. Appreciate it.
My pleasure, John. Until next month.
All right. Thank you so much for listening. Kevin Gregg, again, very kind of him to come on the show. We're both kind of slammed with stuff we're doing, but I get a lot of joy into doing this. It is really a special occasion to have good friends on a show like this. And before leaving, I want to just have some additional words. It's kind of separate than what we do, but it kind of is overlap. Yesterday, I was interviewing Gianfranco de Girolamo. Let's call him Gianfranco. And he brought us something as we can only, this saying that we can only grow as much as our comfort level allows us. He said it a little differently, but we grow to the extent of our discomfort level. And when we hit that, we kind of level off. And so that was a really interesting thought I had yesterday. And today I had read something, I put it on LinkedIn, but it said if in the context of a person like what I do is talking all day on these videos and with clients and with family, there's a good amount of time where I mess up and say things I shouldn't. It creates problems. I'm sure everyone has human experience goes through. And here, when I'm interviewing people or talking with people, for us, we're interviewing clients or talking to judges or talking to other lawyers. It really goes well. It says if a person tells you something that you already know, be silent until they finish, for perhaps they will add something that you did not know before. Then, too, the person derives pleasure from the telling of it. Even if you know they won't add anything, be silent until they finish. So that's silence and holding back your tongue sometimes. Both it'll get you more farther in learning, and it'll help you be just cool with other people. The tongue itself is, although very light in your mouth, it has a very heavy burden because it could do a lot of damage if not used wisely. In the same place I read this had an example that said, a tongue is more dangerous than a sword because for a sword I got to swing it, I can only hit people around me, but with my tongue, I can endanger people across the world by the things I say. So again, talking on the show, blabbering like this, and just talking, sometimes things get out. And it's a real goal of mine to be more mindful of the words I use and how I use them and what effects they have on people. And I just want to share that with you all. I hope to see you in next episode. Have a good one. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.